This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions all about fighting the insurance company. When you deal with an insurance company making claims, some words to think about are no, low, and slow. Chances are they're going to give you one of those tactics. Maybe they're just going to say flat out they're going to deny your claim, and if you accept that, okay, that's what you get. Or maybe they're going to go low. They're going to give you a very low offer for what you're actually entitled to much more. Or maybe they're going to go slow and you can't seem to get in touch with them. They're not answering your calls. They're not returning your emails. Tonight's the night to ask your questions. The 31 Law Call number, call in 536-0077. You can also email us a question. You can email a question to any legal matter any day of the week. You send it to lawcall@waaytv.com. And when we get to a show that's on point, we'll pull some out. We've got some of your questions tonight about fighting the insurance company. We've got Will League here from Timberlake and League. They are personal injury attorneys, and they deal with insurance companies all the time. And when I have insurance questions, I ask them, which company do you use? Do you talk to them? Do you not talk to them?
Right.
Because you deal with these guys all the time.
Yeah, most cases we have had insurance on the backside of it, and what that means really is it's if you and I have an issue and you have to file a claim against me, it's Sharon Doviet versus Will League. But what the jury would not know is there's insurance behind me, and that's by design. And another reasonable counterpoint to that is that maybe a jury, if they knew there was insurance, maybe they'd be more apt to award the plaintiff money.
Oh.
However, you know, it's kind of disingenuous because the way they're tried now is the argument is this poor little defendant has to pay this judgment, him or herself, and you're not allowed to bring up that there's insurance. So it kind of misleads the jury.
Yeah.
We know how that law came into effect, but again, there's a counterpoint to that, and you know, it's debatable, but we're on the blue team.
There's a big insurance
That's
lobby
right.
out there. We've got some video for you. We like to give you, you make the Law Call video. We pull something off of YouTube, and we've got some video tonight.
Well, this is interesting. So one of our partners, Heath Brooks, is at his daughter's birthday party.
No, it is not.
And so we're holding it down for him, and he's going to go for, I think, I don't
No,
know, 360.
y'all are smarter than this.
Heath, be careful, please.
It's frightening. I started to look this up online just to see where this was. This is not local. And you run across so many videos of people doing silly things and they get hurt, and he's about to get hurt. And there's a wall over there or a fence over there. And something like that, just because your friends are holding the bars down to that doesn't mean it's a good idea.
You know, there's a lot going on here. Of course, he's going for it. But again, you know, the homeowner's not liable, swing company's not liable. You have to use it for its intended purpose.
Okay.
I doubt that swing was being used for its intended purpose in that
it's not.
particular video. There is something called an attractive nuisance, whereas let's say you got a pool, trampoline, swing set. If you know kids are coming on your property, you have a affirmative duty to make sure it's safe for kids coming onto the property that may not know they shouldn't. So just because you've got some equipment, if it's an attractive nuisance to a child, then you would have to make sure that that property or playground or whatever is safe for people coming in. You know, we have a lot of cases with summers coming up, a hole in the fence, have a pool in the backyard, and then, you know, a child gets in there and it's a tragedy. And so summertime's coming up, that's something to really look at. Cases like that, insurance companies are involved.
Yeah.
You know, most of the cases that William and I do, we have William Maserbi here with us tonight, and most of the cases we do are against insurance companies. They're the one that hires the attorney.
Okay.
They're the ones that determine whether or not to pay a claim, and they're the ones that are supposed to make any offer that we make to them, take that to their client, which is the insured. Rarely do they do it, and so they usually do it in-house. And so the insured does not know usually that there's been an offer to settle claims within or at policy limits.
Interesting.
And that puts them at odds at times.
William, thank you for being with us tonight. You saw that video too. Do you think insurance is paying for any of that?
I don't think he acted as the reasonable person would under the circumstances, and they probably have some good defenses like assumption of the risk or contributory negligence. Not the best day for that gentleman in the video.
Now, compare that though to somebody just having a car accident. So you make a mistake, you have a car accident, you did something dumb, but not like that dumb. Your insurance would cover you for most things, even when it's a big mistake, right?
Right. Insurance is there to, you know, cover you for negligence and sometimes wanton conduct. Let's say if you're driving down the road, you're flipping to the radio, you mess up, make a mistake. You don't, and really the legal term is, did you act as a reasonably prudent person would do under those or similar circumstances? And if you did not, you caused injury or damage, you are liable. But most of the time, your insurance carrier is liable. An automobile wreck case would be your insurance carrier. They would hire your attorney. They would pay any and all claims. The other side is not to know, or the jury is not to know, that you have that type of coverage. And those are those type of claims. Workers' comp, there's a different type of insurance for people injured on the job. So workers' comp makes all those calls. And usually, sadly, it's us fighting, trying to get our client insurance coverage. William, you handle a lot of workers' comp, and what are most of the things that you fight in terms of trying, I get hurt on the job, I need a knee surgery, and they hire some doctor in California to look at my records and say, you know what, he doesn't need that surgery. How does that compute?
Yeah, so the process is called utilization review, and the last one I handled, it was a retired medical professional of 80-something years old on the Outer Banks of North Carolina. And what they would do is they'll review medical records for a patient they've never seen in a state where they do not reside, and basically say, hey, I appreciate that you have a doctor-patient relationship with your own physician where you are, but I don't think that this is medically necessary. And they can essentially decide from a different state that you don't need the medical care that's been recommended to you by your authorized treating physician. And so it's a problem. Now you can appeal that. That decision has to be appealed first by your doctor, and then when it's appealed by your doctor, it's supposed to get transferred on their end to a different doctor. But the short of it is, even if you win one of those appeals, they've delayed your medical treatment by 2 or 3 months. And you say, well, that might not be so bad, but if the doctor's recommended a back surgery and now you develop foot drop because you have been waiting so long for your surgery to be approved, it creates real issues. The other thing we run into a fair amount in workers' compensation claims is they don't want to pay you temporary total disability, or the 2/3 your average weekly wage that you're entitled to for the time that your authorized treating physician has pulled you out of work. And so those are probably the two most combative, at least early on in a claim process, that we see with workers' comp.
Gotcha.
Most people don't realize workers' comp is so difficult to navigate. And most of you are out there, hey, I'm good, don't need workers' comp.
Do it myself.
I've never been injured before. And all of a sudden you are injured, paycheck stop. Things get real fast when you really need a surgery and you're suffering and you can't get it. I get it. We're Americans. We're hurt. We got Blue Cross Blue Shield. We have all this insurance. But under workers' comp, you are limited to, and you have to go through their physicians, which make it difficult. And we have a lot of people come in, you kidding me? I've got this insurance. I've got Blue Cross Blue Shield. I've got workers' comp. I need the surgery. What gives? So it's a sad situation for a lot of injured workers. And a lot of people think, that's never going to affect me. I hope it doesn't. But most people who come in are just so discouraged from the system. It's a body of law that definitely could use work, and it's really slanted, the other way for the employers to have you go through their system, have them pick the doctors, and it makes a difference.
We've got callers waiting. We've got Howie on the line with a question from Huntsville. Hi, Howie. Thanks for calling. What's your question tonight?
Yeah, a few days ago I got a form letter from an insurance company that says something to the effect of, pursuant to regulation AL ADC 482-1-125-.074, negotiation of settling a claim must not be knowingly ceased or prolonged with the intention of letting the statute of limitations expire. It says that my claim will expire statute on about a year from now. And unfortunately, I don't know what they're talking about. I don't know that I had a claim with an insurance company or that it was negotiations. And when I called them, they wouldn't tell me what it was about. So how do I find out if I have a claim that I'm just not aware of?
So you didn't think you had a claim. You're not waiting on something.
Not that, no. I did slip and fall in the store about a year ago. I'm not sure if that's what they're talking about. They won't tell me, and I don't know how to find out.
That's interesting.
Were you in the military?
No.
I mean, it could be anywhere from a multi-district litigation class action to where, let's say you wore the earplugs from the Army or the military. Let's say you were at Camp Lejeune, ingested some of their water. You could be part of a protected class or a limited class depending on what you were exposed to. There's a lot of Johnson & Johnson baby powder, weed cases. the weed killer that's going around
Yeah.
and hurting folks. So you could be a member of any type of class. I would think you would know if you made a claim from an injury on someone else's premises. Those are some of the issues. But William, they've informed him about a statute of limitations. What's the danger? Why is that important?
Well, the statute of limitations is simply your statutory, or other words, what is the time period codified by law in which you have to either resolve your claim or file a lawsuit if your claim is not yet resolved. And so here in Alabama, we have a 2-year statute of limitations for all claims. Tennessee has 1 year. So it is state dependent. Now, some states do have rules and regulations and laws requiring disclosure of statutes of limitations. And it could simply be, if he filled out an incident report or something like that, and say from this fall in the store, and it got turned over to an insurance carrier, they may be trying to comply with their state law and say, hey, look, we have to inform you of your statute of limitations. But do we have a law like that on the books here, Will?
He mentioned something in that letter about confidentiality in settlement negotiations.
Yeah.
And what that means is, and I don't know the answer to your question because I was kind of daydreaming when you were talking, William, but you asked me again.
Yeah, well, this is just simply, to my knowledge, we don't have any law in the state of Alabama that that an insurance company has to tell you or disclose to you your statute of limitations.
Right. That's right. So a lot of times, if let's say you're negotiating, there's a 2-year statute of limitations. They say, it's going to be 2 years next week. We'll get back with you in 3 weeks. Well, if you don't know the statute of limitations means your case will fall like a guillotine and is done. You cannot bring it after the statute of limitations, which is 2 years from the date of the incident, and maybe other times, other jurisdictions for other claims. But if the point is, if you know your statute of limitations, you know that when you must file a claim or it is lost forever. Another part of that letter said that the negotiations on settlements are not to be disclosed to the jury. So anything that you negotiate in terms of trying to get something settled usually is not admissible if the negotiations fail and you're able to go to court. And there's a good reasoning behind that, is you want parties to be able to openly engage in dialogue to try and resolve the cases. Let's face it, there are a lot of cases being filed, a lot of backlogs in jury trials, judge trials, and the law, encourages people to get together, try and resolve the differences. And oftentimes, if you have at least a say in the outcome of your case, in the outcome of the litigation that you're in, then oftentimes the plaintiff and defendant will be happier given that they at least had a say in the process.
Yeah.
And the inverse of that is true as well, which is you can't go into court and say, hey, 2 weeks ago the insurance company offered me $15,000.
Yeah.
So that is one of those rules that cuts both ways.
They're telling us take a break. We're going to take a break. Be right back. If you're on the phone, stay on the line. We'll be right back. More answering your questions about fighting the insurance company. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet, with the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions all about fighting the insurance company. We've got with us both Will League and William Meservey from Timberlake and League, and they fight with the insurance company all the time. And we've got callers waiting. Sarah has been waiting. Sarah, thanks for calling from Huntsville. What's your question tonight? Sarah, you still there? You are. Yeah, go ahead.
Hey, I've been with this insurance company for past 32 years. We have a home and auto bundled together, and we have 2 homes and several cars. And last year, during the summertime, we had some roof damage because of the hail and storm, which we tried to claim with the insurance company, completely denied, and we already paid and we repaired it. Okay. But then again, past few months, we had again storm damage, and it took a lot of shingles off of the roof. And I hired another roofing company, and they send 2 adjusters so far, and both times they completely denied for replacing the whole roof, which is exactly what it needs. They're just saying that we pay only for missing shingles, and the roofer told them that, okay, it's not enough because most of the woods under the shingles are completely damaged. It's softened, and it's beyond repair. It needs to be replaced.
How frustrating. She's been a customer 32 years.
William, what do you think?
You know, so it's worth taking a look at. What you have to show in making a claim against your homeowner's insurance for storm damage, and even if it's not storm damage and we're just talking about a leak, it has to be essentially acute damage. In other words, you have to be able to show that, hey, this damage occurred, you know, in a matter of seconds, versus if it's a slow leak over time, then that gives them an out. They don't have to pay for slow over time developing damage. And so, you know, here, if the argument they're making is that, you know, what was under the shingles has been softened, and that's due to something that occurred over time versus something acute from a storm, then it may give them an out, and you may need some form of expert testimony in order to dispute their position on the claim.
Sounds like she's got her ducks in a row. She's got a roofer there talking to the insurance company. That may be your expert testimony. You'd have to show, again, that it was acute damage to your property. You got to prove that. And if they denied it, it could be a breach of contract. So you have to file a breach of contract claim, sue your own insurance company for breach of contract, bring your expert in and say, hey, I've inspected the roof. In my expert opinion, it was caused during the storm. We need to replace it for X amount, and then be up to a judge or jury to determine whether or not, and they may bring their expert to say it wasn't, unless you've got some sort of clause in your insurance policy saying we only replace shingles or a limited benefit under some exclusion. But I'd check with a lawyer sooner rather than later, because remember, we've talked about statute of limitations tonight. You don't want that to pass.
The other thing that happens is it's not just your statute of limitations. You know, it's not like TV where they come out with yellow tape and tape off the scene and let you collect the data and the evidence. And so the more time that goes by without an expert inspecting the roof gives them more opportunities to say, well, there's also a storm 3 weeks later, and, you know, this, that, and other. And so, you know, it can create defenses for them, but particularly in premises liability cases and auto accidents, and even something like this, you need to take lots of photographs. You need to document the evidence, because no one else is going to go out there and do that unless you immediately go to a lawyer's office, you know, and we know that you've got to go investigate that scene. You've got to get the photographs. You've got to get the evidence before it disappears. And then, Will, how many folks have come in the office, in your office, and said, hey, look, this happened, but it was 1.5 years ago. And you say, do we have any evidence? Do we have any photos? Do we know what the liquid on the floor that you slipped on was? And more times than not, if someone's waited that long, most of that evidence is going to have disappeared. You
know, and it cuts both ways. Obviously, it cuts both ways. I'd rather have photographs. Evidence is like water in the sun. It gets splashed around, it evaporates. And I've had jurors come up to me after a trial and say, well, I know your client had these photographs, but he or she must have been planning a lawsuit because they took those.
Oh, they'll read it both ways.
Yeah, and I've had jurors say, well, you know, had we had photographs, we'd have known. And so a skeptical juror is going to come up with any reasoning to be in line with what he or she thinks before they get in the jury. And so that's unfortunate. So I remind folks, have an open mind when you go in there. But again, it is better practice to preserve the evidence and have as much available to you if you have to try that case.
We've got Larry on the line with a question from Decatur. Hi, Larry. Thanks for calling. What's your question tonight?
Well, my question is that my sister-in-law, her car broke down, and she borrowed her daughter's car, and she lives at the high-rise here in Decatur, Alabama.
Okay.
And this guy, he stepped on the gas instead of the brake, and he went in between two cars that was parked side by side one another. So he wiped out the driver's side of my daughter,
your daughter's car?
Well, no, it's not my daughter.
The car she was driving.
It's my sister-in-law.
I got
Okay.
you.
Okay. Anyway, he wiped out the side of her car, and then he went on up and he hit the building.
Okay.
Okay, the insurance company is telling them that they can't do anything with them as far as paying for damage because they got to wait and see how much it costs to fix the building, and said that he may not have enough coverage to cover her car.
Yeah.
Now, have
So
you
this
heard
is-
anything like that?
Yeah, so this is why full coverage is so important. Every insurance policy is going to have a policy limit, meaning that they will cover damages up to X amount of dollars. And that limit in the state of Alabama, the minimum required by law, is typically $25,000, and that applies to property damage as well. And so here, if they have a minimal policy of liability insurance that's responsible for up to $25,000 worth of damages, you know, you essentially can have a situation where you have two or more parties both going after that same sum of money for an amount that exceeds the policy limits. And so then some sort of agreement has to be reached, or if you have full coverage on your automobile, then your own collision policy will make up the difference. But it's not uncommon. In fact, it's very common that every insurance policy written is going to have some certain policy limit of, essentially capping the limit of their damages.
So it's not like the first one to get that money gets to keep it all. They're going to do it in percentages or
Right,
something?
they'll apportion it among the damaged parties.
Okay.
So you got the house, you got her car, so they'll apportion that. But she can, your sister-in-law can also go for her own coverage if she's got comprehensive collision, those type things,
Okay.
To see if they would cover it as well. So that might give her some additional relief.
Okay. They're telling us take a break. We're going to take a break. Be right back answering more of your questions about fighting the insurance company. If you didn't get your questions answered tonight, here's how to get in touch with Will League and William Meservey with Timberlake and League, personal injury attorneys. So that's everything from medical malpractice to fighting the insurance company. 256-536-0770 or 800-804-2502. The website is law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon Doviet, family law attorney, 539-7337, divorce, child custody, SharonFamilyLaw.com.
In our last seconds, the insurance company calls, they want to talk to you. Do you have to talk to them?
If it's your insurance company, there may be a clause in there that you have to cooperate and assist in the investigation. If it's the other insurance company, you do not have to give them a statement.
Okay.
Oftentimes, the statements are designed to deny your claim. William, what do you
Always a
tell
good
us?
idea to talk to your lawyer before you give, a statement, even to your own insurance company. There is a requirement that you timely notify them and that you cooperate with them. There's nothing that says you have to give them a statement right when they call. Talk to your lawyer first.
And it's oftentimes, you got a legitimate claim, an innocent, if my mother was going to give a statement, just an innocent, I was on my way to church and I was just running late. Well, they'll take that to you're running late, to you're in a hurry, you're inattentive. And so it's an innocent statement could come back to bite you, and believe me, they will use it against you.
Thanks for all your questions tonight, and we'll see you next week.
Good night.